then cut over to 2. I said, that's all I can do. He goes, by temp. for them to move.
Yeah, I mean,
indicated to me, and you talked about a couple of things. Mr. Matthews is representing you this morning in his trial, and I expect that you will cooperate with him. If you have any, I sense you may have a desire to kind of interject things based on our last meeting. I want to make sure that you understand that you are, unless you're testifying, you're not to talk. You can talk to Mr. Matthews confidentially, of course, but I don't want to see any talking out of turn or comments or things like that. You understand that?
Yes, I do.
Okay. All right. Everybody ready to go?
Yes.
All right, go get him and then come and get me.
All rise.
What did we do without him? Great.
Ladies and gentlemen, make sure your cell phones are turned off, please.
All rise.
Seated, please. Good morning, ladies and gentlemen. I want to welcome everybody to the Lake County Courthouse this morning. My name is John O'Donnell. I will preside throughout this trial. With us is Carl DeFranco, the Lake County Clerk of Courts. He's going to swear you in. If you would stand, please raise your right hand and respond. I will. Go ahead.
Do you solemnly swear or affirm that you will truly and fully answer all questions put to you by the court or counsel in this case, and this you do as you shall answer unto God? Thank you.
Thank you, Mr. DeFranco. I know this is your first opportunity for jury service, and you watched a video this morning that tells you a little bit about what to expect for your service as a juror, but I'm going to give you a little bit more of an introduction to jury service before we get started. Service as a juror is an important civic duty. Trial by jury is one of the most valuable rights that we all possess in the United States, and that preservation of that right is strengthened by your response in being here this morning. Now, I recognize that each of you are making some sacrifice by being present today, and I know it represents some inconvenience to each of you, but I also believe you will recognize that jury service is necessary. The jury system that we use is a system that lets everyday people decide issues that affect other everyday people. So the sacrifice being made by you is a sacrifice necessary to ensure that we continue the jury system. Now, I recognize that some of you may be feeling a bit nervous or stressed at the thought of having to serve as a juror. Those are common feelings often expressed by jurors that have never served before. Many people think they don't know what jury duty entails, or that they're capable of performing the duties of a juror, and I want to assure everybody that you're more than capable of performing the duties of a juror. Now, it's my hope that your service as a juror or a prospective juror will be an interesting and rewarding experience. And those selected who hear the case after the trial is done, when I talk to jurors after jury trials, they almost universally indicate that they enjoyed their service and are interested in coming back again. So once again, I want to thank you for being here this morning. You've been summoned as prospective jurors in the criminal case entitled State of Ohio versus Toussaint Burrell. Mr. Burrell is a defendant in this case, meaning that he is charged with committing a criminal offense. Specifically, the indictment alleges in count 1 that on or about May 30, 2025, in the city of Painesville, Lake County, Ohio, Toussaint Burrell did knowingly obtain, possess, or use cocaine or a compound mixture, preparation, or substance containing cocaine, a Schedule II controlled substance. The amount of cocaine did not equal or exceed 5 grams. It was alleged to be 2.71 grams. In count 2, the defendant is charged with illegal conveyance of drugs of abuse under the grounds of a specified governmental facility. The allegation is on or about the 30th day of May 2025 in the city of Painesville, Lake County, Ohio, Toussaint Burrell did knowingly convey or attempt to convey under the grounds of a detention facility or of an institution, office, or building or other place that is under the control of the Department of Mental Health and Addiction Services, the Department of Disabilities, the Department of Youth Services, or the Department of Rehabilitation and Correction. A drug of abuse is defined as in 3719.011 of the revised code. The indictment filed in this case, which sets forth the charges read to you, is not evidence. It is used to inform Mr. Burrell that he has been charged with the offenses. The fact that it was filed may not be considered for any other purpose. Mr. Burrell has pled not guilty to the charges. A plea of not guilty is a denial of the charges and puts in issue all the essential elements of each offense. The state of Ohio and Mr. Burrell are entitled to jurors who approach this case with open minds until such time as a verdict is reached. It would be unfair and improper for you to decide this case based only on part of the evidence or without hearing the court's instructions and the arguments of counsel. Do not jump to conclusions on the basis of the first or the last argument or the first or last evidence presented to you. In addition, jurors must be free as humanly possible from bias, prejudice, or sympathy and not influenced by preconceived ideas either as to the facts or to the law. You will receive the facts from the witness stand. Instructions as to the law will be given to you by the court, and it is your sworn duty to accept and apply the instructions that are given to you. I want to begin explaining the procedure by which some of you will be selected to serve as jurors in this case. As I said, each of you are undoubtedly qualified to serve as a juror. However, there could be something that could disqualify you in this particular case or under the particular specific facts and issues presented in this case. So we're going to go through a process whereby I ask you questions and the attorneys ask you questions. This part of the trial is called voir dire. It's an opportunity for the court and the attorneys to ask you questions in an attempt to learn a little bit about your background to make sure that you can be fair and impartial jurors in this case. These questions are not designed to pry into your personal affairs, but to discover if you have any knowledge of the case or any preconceived opinion which you cannot set aside, or if you have had any experience in your personal or family life that would cause you to favor either party. These questions are necessary to assure each party has a fair jury. I will ask you some questions first as a group. If you have a response, raise your hand and I'll call on you. Every time an individual speaks, the juror number must be stated by either the individual juror or whoever's doing the questioning. This is necessary so we have a record of who is talking at the time. After I've asked my questions, the attorneys will ask questions as well. And these questions, once again, are not intended to be offensive or to pry, but to find out that you can be fair and impartial in this case. Now, I'm sure that you would understand that if a person has a preconceived idea as to how this case should come out or some other interest in this case, that person would not be able to serve as a juror. That person would be excused for what is called good cause. After I'm done being, after we are done questioning you, you will be excused. I'll meet with counsel out of your presence, at which time 13 individuals will be chosen to serve as jurors in this case. One of the 13 will be the alternate, and that person will not be identified until just before deliberations begin. Now, it's important that you be open and honest as this questioning goes on. If you are not open and honest, we can't get necessarily a fair and impartial jury. So we need you to be open and honest. If when you're being questioned by either me or one of the attorneys, if there's something you don't want to talk about in front of the whole panel, let me know that, and we'll talk individually at that time. Now, seated directly in front of me, representing the state of Ohio, are Assistant Lake County Prosecuting Attorneys Abigail Bell and Emily Contour. Would you introduce yourselves, please?
Good morning, my name is Abigail Bell. Good morning, I'm Emily Contour, and we have at trial table with us Deputy Justin Nevison of the Lake County Sheriff's Office.
And seated at the other table is Attorney James Matthews. Mr. Matthews, introduce yourself and your client, please.
Good morning, everyone. My name is Jim Matthews. This is my client, Tucson Pearl.
Thank you. Stan Shadowin is our bailiff. It's his responsibility to keep you together and not to permit you to talk to any person or allow any person to communicate with you during the trial. Kathy Miller is our court reporter. She's responsible for recording and taking down everything that is said in court. It's very important that the witnesses, the jurors, and the lawyers speak clearly and loudly enough for Ms. Miller to hear them. And because people have a tendency to nod in response to a question, you're occasionally going to hear me remind you that you got to verbalize your answer so she can take that down. Now, those who participate in a trial must do so in accordance with established rules. This applies to the witnesses, the lawyers, the judge, and the jurors. The lawyers present the evidence through the questioning of witnesses, which must be done according to the rules. The judge enforces the rules and determines what evidence may be admitted. At times during the trial, a lawyer may make an objection to a question asked by another lawyer or to an answer by a witness. This simply means the lawyer is requesting that I make a decision on a particular rule of law. Do not draw any conclusions from the objections or my ruling on the objections. These simply relate to legal questions that I must determine and should not influence your thinking. As jurors, you will be the sole judges of the facts, the credibility or believability of the witnesses, and the weight to be given to the evidence. Later, the court will furnish the law which you will apply to these facts. It is your sworn duty to accept the law as it is given to you by the court. Once the jury is selected, the procedure for the trial is as follows. First, the state will outline in an opening statement what they expect their evidence will show. The defense may then, but need not make an opening statement. These opening statements are not evidence. They are a preview of the claims of each party designed to assist you to follow the evidence as it is presented to you. Then the state offers evidence to support its claim. The defendant may then present evidence but is not required to do so. If the defense does offer evidence, then the state may offer rebuttal evidence. The trial concludes with the instructions of law and the arguments of counsel. You would then deliberate on your verdict. A criminal case begins with the filing of an indictment. The indictment informs the defendant he has been charged with an offense. The fact that it was filed may not be considered for any other purpose. The plea of not guilty is a denial of the charge and puts in issue all the essential elements of each offense. The defendant is presumed innocent until his guilt is established beyond a reasonable doubt. The burden of proof is on the state of Ohio to prove the facts necessary for its case beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you of his guilt beyond a reasonable doubt of every essential element of the offenses charged in the indictment. Reasonable doubt is present when, after you have carefully considered and compared all the evidence, you cannot say you are firmly convinced of the truth of the charge. Reasonable doubt is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. Evidence is all the testimony received from the witnesses, the exhibits admitted during the trial, facts agreed to by counsel, and any facts the court requires you to accept as true. Evidence may be direct or circumstantial or both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which he or she testifies. It includes exhibits admitted into evidence during the trial. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. Direct evidence and circumstantial evidence are of equal weight. The evidence does not include the indictment or the opening statements or closing arguments of counsel. The opening statements and closing arguments of counsel are designed to assist you. They are not evidence. You are the sole judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witnesses. To weigh the evidence, or you may apply the test of truthfulness which you apply in your daily lives. These tests may include, but are not limited to, the appearance of each witness upon the stand, the reasonableness of the testimony, the opportunity to see, hear, and know the things concerning which they testified, the accuracy of memory, frankness or lack of it, interest and bias, if any, together with all the facts and circumstances surrounding the testimony. Applying these tests, you may assign to the testimony of each witness such weight as you deem proper. You are not required to believe the testimony of any witness simply because they were under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your province to determine what testimony is worthy of belief and what testimony is not worthy of belief. The testimony of a defendant is to be weighed by the same rules that apply to other witnesses if the defendant takes a stand and testifies. The defendant has a constitutional right to not testify at trial. If the defendant chooses not to testify, you shall not consider that decision for any purpose. You should not decide any issue of fact merely on the basis of the number of witnesses who testify on each side of an issue. Rather, the final test in judging evidence would be the force and the weight of the evidence regardless of the number of witnesses on each side of an issue. The testimony of one witness believed by you is sufficient to prove any fact. The court instructs you not to converse with the attorneys, parties, or witnesses during the trial. Likewise, the participants in the trial must not converse with you, and in fact, they are ordered not to talk to you until after the case has concluded. If anyone should attempt to discuss the case with you, report that incident to me or the bailiff immediately. Do not investigate or attempt to obtain additional information about this case outside of the courtroom. It is improper for any of you to attempt to do so. You are instructed not to read, view, or listen to any report in any media on the subject of this trial and do not permit anyone to read or comment upon them in your presence. Such reports may be complete and inaccurate. You may only consider and decide this case upon the evidence received at the trial. If you acquire any information from an outside source, you must report it. If you realize during the course of the trial you have personal knowledge of any facts in this case, you must report that to the bailiff immediately. Now, as I said, I'm going to ask you questions first, and if you have a response to that question, please raise your hand and we'll talk a little bit more about it. First question that I have of you, does anybody know any of the three attorneys in this case? Anybody know the officer or Mr. Burrell? Anybody know me? Number 21, how do you know me?
A little bit.
Okay. Have we met?
I just know you from when you were councilman and stuff.
Okay. Was I a good councilman or a bad councilman? No comment, huh? All right. Would that, if you're selected to serve, would that influence you in any way?
No.
Okay. Anybody else? All right. Do any of the potential jurors know each other?
I do.
Okay, now, I'm going to ask you who that is, but you got to tell me juror numbers, okay? Who do you know?
I believe it's number 10, John Manning.
Can't use names.
Oh, I'm sorry.
That's all right.
Number 10, sorry.
All right, how do you know number 10?
His wife and I worked together several years ago and we kept in touch on it.
Okay, when's the last time you had any contact with either number 10 or his wife?
I honestly can't say, it's been some time.
Okay. And if you're selected to serve and juror number 10 is selected to serve, let's say that you went back there to deliberate and you thought it should come out one way based on the evidence and the law, and he thought the other way. Would that impact your relationship such as it is going forward?
No, sir, I don't believe so.
If he gave his argument as to why he thought you were wrong, would you listen to his argument?
Yes, sir.
Would you consider what he says?
Yes, sir.
All right. And if you still disagreed, would you stick to your guns?
Yes, I believe
All
so.
Okay, number 10, same question to you. When's the last time you would have seen number 2, do you think?
I can't remember, Your Honor.
Okay.
It's been quite some time. I've been divorced from my ex-wife for 20 years, so.
Okay. So would that, the existence of that?
I apologize, Judge, it's number 14, I'm sorry.
Oh, okay.
The number's wrong. My apologies. Sorry, sir.
It's all right.
All right. Okay, so it's been a while since you've seen
Yes.
14.
I looked at
All right.
the numbers wrong, my apologies.
Okay,
My
so-
memory's not very good, I guess.
All right, so 14, tell me the last time you had any interaction with juror number 2.
Gotta be like 10+ years ago.
Okay. I asked her a bunch of questions about what would happen in deliberations if you guys disagreed. Are your answers any different?
No, sir.
All right. You would listen to her argument?
Sure.
You would consider her arguments?
Yes,
All right, and if you disagreed, you would stay with what you believe?
absolutely.
Okay, thank you. Anybody else know any other potential jurors? I read you the allegations that are contained in the indictment. Does that ring a bell to anybody? All right, now, has anybody had any prior jury service, and by that I mean, has anybody actually served, gone through this process, been picked and served as a juror? Okay, let's start with your number, please. Number 24, tell me about your prior jury service.
It was 2021, I think, downtown, and the courts was during COVID, and it was also a drug weapons case.
Was it, so it was in common pleas court down at the Justice Center? Or was it federal court?
Federal.
Federal court, okay.
Yes.
And so you deliberate on a verdict?
Yes.
All right, did that jury reach a conclusion?
Yes.
All right. Anything about your service in that case that would impact your ability to serve as a juror in this case?
I don't think so.
All right, now, during that case, obviously the facts were different than they're gonna be in this case. And the instructions of, do you remember the instructions of law you were given? I'm sure it was a thrill a minute, but do you remember them still? Okay, if you're selected to serve and you're sitting there and you're listening to my instructions and you think, well, that's not what the last guy said 5 years ago, I don't think he's right, would you discount what you knew about it, what you thought about it, what you heard back then, and consider only the law that I give you?
Oh, yes.
Okay. Any problem doing that at all? All right. Okay, some other hands went up back there. What, your number, sir, way in the back?
36,
All right, and when did you serve?
October of 24,
And where was that?
here, not in your court, but upstairs,
Okay, was that a criminal case or a civil case?
our criminal case.
And did that jury reach a verdict?
Yes, it did.
Okay. Anything about your service in that trial that would impact you from serving here?
No,
Okay. Would you be able to set aside the instructions you got and the facts you found in that case and consider only this case on the facts and the law that I give you?
yes, sir.
All right. And I thought there were more hands up than that. Number 33, go ahead.
It was a drug-related case in this, in Lake County Court, and it was back in the late 1980s.
Okay. What do you remember about that case?
We did come to conclusion, we convicted the individual, and it was very
Did you enjoy your jury service?
Yes, there was lots of bickering and arguing and lots of swearing.
Oh. Not by you, I take it. All right, so if you're seated in this case, you've heard the questions that I've asked the others. Would you set aside your knowledge of whatever drug laws existed at that time and the state of the law and follow my instructions?
Yes.
Okay. Anybody else? Okay. Has anybody had any prior legal training of any sort, meaning as a law enforcement or things like a paralegal or schooling, things like that? Your number, please?
27,
And tell me about what legal training you've had.
worked for law firms in Cleveland,
In what capacity?
secretary, paralegal, certificates, and associate's degree from Westland,
All right. And how long did you perform that function?
probably 20 years.
And are you still doing that?
Yeah,
When did you stop doing that?
about 10 years ago.
Did you perform any in that job anything in the criminal law?
No.
Okay. Would you, if you're selected here, and you remember at least from training, not necessarily from employment, but from training, something different than what you think should be going on here or what the instructions are, would you set that aside and consider this case only on the facts that you find in the law that I give you?
Yes, sir.
Would you have any trouble at all doing that?
No.
Okay, anybody else? Number 9, go ahead.
I went to college for a short period of time for criminal justice.
And how long ago was that?
2009, 2010.
Okay, anything about that experience that would prevent you from listening to these facts and following the law here?
No.
Okay. Anybody else? Number 1, go ahead.
I took a criminal intelligence course in college,
And how long ago was that?
about a year ago, year and a half ago.
Is there anything with regard to that class that you think would interfere with your ability to be fair to both sides here?
I think so.
Okay, if you're chosen and you deliberate and you remember something from that course that just doesn't kind of mesh with what you hear in this case, the evidence or the law, would you discount that and decide this case based only on the evidence you hear and the law you receive?
I may bring it up, I'm not sure,
Okay.
during deliberation.
All right, well, do you understand that the only evidence you can consider is what you hear from the witness stand and what exhibits you see? That's all you could consider in this case? Okay, would you commit to doing that?
Yes, Your Honor.
Okay, anybody else? Number 5, go ahead.
Every 2 years, I have to take law, like certification for my nursing license. I don't know if it pertains to this or not.
Okay, when's the last time you did that?
Last October.
Did it involve anything having to do with criminal law? Okay. And once again, I just asked gentleman number 1 the same question. Will you make sure that you confine your decision based upon the evidence you hear and the law that I give you?
Yes.
Okay. Anybody else? Number 6, go ahead.
I have the same, I have a 2-year continuing education credit. I have Ohio law pertaining to nursing practice.
Okay. Anything about that would interfere with you being fair and impartial to both sides here? Okay, anybody else? Number 23, go ahead.
The same for me.
A lot of nurses here today, huh? I hope nobody's getting sick out there. Anything different from 5 or 6?
No, sir.
Okay. Anybody else? And, okay, 34? Okay. Same answer as them? All right. All right. Any other nurses in the crowd? All right. Anybody else with regard to that subject area? All right. Does anybody, and I'll kind of lump all these things together, anybody have any ethical, moral, religious, philosophical views that would prevent them from serving as a juror in this case? Okay. Now, it's my expectation, in talking to the attorneys before we got started here, that you will likely hear all the evidence, all the witnesses, and all the exhibits by the end of today. So this trial is expected to last today and maybe into tomorrow. Now, other than everybody's got work and family obligations, things of that nature, is there anything that prevents, beyond those things, anything that prevents anybody from sitting here and hearing this case for, let's just call it at the outside, probably a day and a half? Okay. Does anybody have any physical problems that would prevent them from sitting as a juror in this case? Any back problems, things of that nature? All right, 21, go ahead.
Yeah, I've had about 4 back surgeries, and the last one was in 24. And sometimes it bothers me to sit for a while or stand for a while.
Okay. Now, we usually, we will take breaks usually between an hour and 45, or an hour and a half, an hour 45, somewhere in there. We'll always get a 15-minute break. Would that prevent you from sitting for periods of that long?
No, that would be fine.
Okay. And if say an hour in, your back's starting to bother you sitting down, you can also just stand up until you become more comfortable. Okay. All right. Anybody else? Now, has anybody, as you've been sitting here since about 8:20, formed any opinions about this trial and how it should come out? Okay. Now, as I said, it's the duty of the jury to decide whether or not the defendant is guilty of the crimes charged in the indictment. If he is found guilty, it becomes my duty to determine what sentence is imposed, and I make this decision with the benefit of other information that is not relevant for the purpose of you guys as fact finders, but it's other background information that I would utilize in fashioning a sentence. Does anyone think they cannot perform their duty in determining whether or not the defendant is guilty or not guilty of these charges without thinking about what may happen if he's found guilty? In other words, can you put any potential sentence out of your mind since it's out of your purview? Anybody have a problem doing that? Okay. All right, in a minute here, I'm going to turn it over to the state, the prosecutors, to begin questioning you. Counsel for the state will inquire first, followed by counsel for the defendant. I want to remind you what they say or what they do is not evidence. Evidence is all the testimony received from the witnesses and the exhibits admitted during the trial, any facts agreed to by counsel, and any fact which I require you to accept as true. Since it is your duty to decide this case solely on the evidence as is later defined for you, you must not consider as evidence any statement or act of any attorney made during the trial, including during voir dire. Ms. Bell?
Thank you, Your Honor. Good morning. Can everyone see me, hear me, talking loud enough? Let me know, raise your hand, I'll project or move closer. So as the judge already said, I'm Abigail Bell. Together with Ms. Contour, we represent the state of Ohio. We work for the Lake County Prosecutor's Office under Mr. Charles Colson. We have Deputy Nevison here with us. I want to thank you all for coming out on this extremely cold morning, right? Coldest of the year. being here bright and early on a Tuesday morning. I know that took rearranging of your schedules, and we really do appreciate it. Okay, I'm gonna go through the witnesses that we expect to bring here today, and just let me know if you know these people. Lieutenant Mario Eldridge, Ramon Mercado, Gavin Ellinger, Garrett Mason, Sergeant William Anderson, and J. Zachary Dawson. So voir dire is the time for us to get to know a little bit about you, and it's actually the only time during this case that we can talk to you. So the rest of the trial, we can't speak. I know that we're not trying to be rude. If you hold the door open for me and I don't say thank you, I can't. I appreciate it, but I'm not being rude. So this purpose of voir dire is so we can determine who will be a good juror for this specific case. So we ask that you be open and honest. There are no wrong answers. And our goal here is to select a jury who will be fair and impartial to both sides. And I might ask you some personal questions. Again, I'm not, wanting to pry or embarrass you. We just want to see who can be fair and impartial, and you can always ask to answer that question in private. There's nothing wrong with that. So as you sit here today, does anyone feel an allegiance with one table versus the other? Okay, we're all coming in on an even ground, even footing. And the defendant is charged with possession of cocaine. And the judge is going to give you the specific definition that makes up that charge. Based on hearing the charge alone, is there anyone that feels like they cannot sit as a juror? Number 30?
We have one question for you. Why am I the only person here for color?
So it's picked based on voter registry, so it's just whoever is registered to vote in Lake County.
Well, let me give you a little bit better explanation of that. Every year, there's an inventory of registered voters in Lake County. And so when this is the second panel that we've had. First panel that we've had, you're in your third week. So everybody here, your name was drawn, and I then begin to select jurors or to get a panel of jurors based on the first one all the way down. I think there's over 100,000, maybe 120,000 registered in Lake County. So you're on a list of 1 to 120,000, and the order that you're selected at random is the order that you're brought in. So that's how the juror pools are drawn. Now, for instance, you're the only one here out of 36. I had a trial, I think 3 years ago, on a civil trial where we have only 8 jurors, where 3 of the individuals were black. So it just, sometimes we get a better mix, sometimes we don't, but everything is a random, and you're brought in the order that you're in, okay?
That being said, being open and honest, as you put it, I do not feel this is fair.
Okay.
At all.
Well, we could have, I guess, I understand what your statement. We could have a discussion as to how jurors are drawn, but there's two ways. There's 2 ways that different counties draw different jurors. Some do it, well, actually 3 ways. The way we do it, by voter registration. There are some that do it simply by motor vehicle registration. And the problem with that generally is that people move. So you get a lot of people that are summoned to appear that live in this case, they would live in Geauga or Cuyahoga or Ashtabula. So that doesn't seem very effective, or there's a combination of both. But that's how we do it, and that's the explanation I can give you. Okay? All right. Ms. Bell?
Thank you, Judge. All right. So moving to, well, does anyone, just hearing possession of cocaine, anyone have any gut reaction? You don't feel like you should be here? Same question for illegal conveyance of drugs of abuse onto grounds of a specified government facility. right, so everyone here in the courtroom today serves a different function. For example, my job is to represent the state of Ohio and to present evidence to you of the defendant's guilt. The court reporter's job is to take down everything that's being said here today. Your job is to decide the facts. The judge's job is to provide the law. And sometimes the law is not what you expect or what you think. Does anyone here watch CSI, listen to true crime podcasts, anything like that? Hands? Okay. If you've listened to, number two, if you've listened to a true crime pod, well, what do you listen to or what do you watch?
I don't listen to podcasts, I watch like Law and Order, all those kind of things. I admit it. It came up earlier on the video, but I'm guilty of that.
Okay. And are there courtroom scenes in those
Yes.
shows?
Correct, yes.
So you know that those are actors?
Correct.
Okay.
Yes.
So if I, have to shuffle my papers or stumble over my words, will you hold that against me? Same for Mr. Matthews.
That's correct.
Anyone have a different answer to that question? Now, if you watch these shows or listen to these podcasts, whatever, and the law is different, maybe it takes place in a different state, different jurisdiction, are you able to apply the law that the judge has given you in this case?
Yes, I am. Yes.
Everyone else feels good about that?
It's really strictly for entertainment. I just like it though.
See, for us it feels like work, so we don't.
I don't look a lot into it, so.
Everyone have the same answer? If the law is different than what you think it should be, would anyone have trouble following it? So the facts are going to be testimony you hear from the witness stand, the evidence you're going to see broadcast here, there'll be physical evidence for you to touch. And after all that evidence is presented, that's when you get to make your decision. And that's going to be based on reason and common sense. Just based on your everyday experience, you apply it to those facts. It's also going to be your job to judge the credibility of witnesses. Again, you'll use your common sense and life experience to do that. Does anyone think they'll have difficulty determining if someone is credible or not? So as a state, we have the burden of proof. That's proof beyond a reasonable doubt. And we have to prove that the defendant is guilty beyond a reasonable doubt. And the defendant has no burden. The judge will give you an instruction about what that means. But does anyone have a preconceived notion of what beyond a reasonable doubt means? Does anyone think it means no doubt or beyond a shadow of a doubt? Do we all agree to listen to the judge's instruction on beyond a reasonable doubt? So every crime is made up of elements, and it's the state's job to prove those elements to you beyond a reasonable doubt. And if we don't prove one of those elements, you cannot find the defendant guilty. You have to prove every single one. Now the converse of that is that we only need to prove the elements. We don't have to prove motive. You might still have questions. If you have questions or just want to know more about the case, would anyone have trouble returning a guilty verdict even if all the elements were met? And can we all agree not to hold the state to a higher burden? We have a relatively short case for you today. I've listed the witnesses. And can we all agree that the quality of the evidence is more important than quantity? Can you hear something from one witness and be convinced of the truth? Do you think, would anyone here have trouble coming to a decision based on the testimony of just one person? Number 18?
Yeah, I don't think I can listen to one person give a statement because we don't know if he's 100% truthful.
Okay.
Whether he's on oath or not, so I think it's gonna take more than one person as a witness.
And that's,
Unless it's an extremely credible person.
all right, yeah, so that goes back to my credibility question.
Yeah.
Okay. So if you judge the person to be very credible, could that person convince you? of what
Yeah,
the
if I was
saying is
convinced
true.
the person was 100% credible, I could do that, but there's not too many people I can say are 100% credible. It's a thin list.
So if the witness you felt was not credible, you would not take into consideration what they were saying?
I would consider it, but would I believe it?
Okay, so you would weigh it
I would
appropriately,
have to weigh that. yes.
using your reason and common sense? Number
I
one?
agree with that as well.
Okay, that's a good way to be. All right. Has anyone been convicted of any type of crime? Again, if you want to answer privately. Number three?
Yeah, I've got a felony in possession.
Okay. In Lake County?
Yes.
From when?
2019-ish, 2020.
Did you go to trial?
No.
So you have an understanding of what the law is. Would you be able to put aside your knowledge about what the law is and your experience and be fair and impartial in this case?
Yes.
Anyone else? 16?
Misdemeanor, fair play.
Okay. Same questions. Would you be able to put aside your experience in your case and be fair and impartial here? 19?
Possession, like 2009.
Okay. Same questions. Oh, and sorry, you were shaking your head. Was that a yes?
Yes.
Okay. Can't see your number.
35.
35?
I had an issue in 1999. I'd rather speak privately.
Sure. That was 35.
35.
Anyone else? 11?
I had a misdemeanor in 2008 for disorderly conduct.
Okay. You'll be able to put your experience aside and be fair and impartial in this case?
Yeah.
Okay. So being a juror means you have to sit in judgment of another man. Again, you'll listen to the facts, you'll hear all the evidence, then you'll have to come to a decision whether the defendant is guilty or not guilty. Does anyone have any philosophical, moral, religious objection to sitting in judgment of another man? 30?
Absolutely.
Okay. What is that objection?
Private.
Sure. Okay, anyone else? Does anyone have any friends or family or yourself that's in law enforcement? Police officer, anything like that? Oh, lots of hands. Okay, number one.
Yeah, my brother's in law enforcement.
What kind?
He's a police officer.
Officer. Where does he work?
North Carolina.
Oh, okay. So do you see him often?
I do.
And do you talk about work with him?
Sometimes.
Would you be able to put aside whatever he tells you about work and just listen to the facts and the laws you hear here today?
Try.
You can try?
It's really hard. Like, I feel like I talk to him a lot, so.
Okay.
Yeah, but I would try this.
You recognize the law in North Carolina is different than Ohio, so you could try to put that aside?
Yeah, I could put aside the differences there.
So more hands. Two?
Yes, I have a cousin who's an Eastlake police officer.
Okay. And do you talk with them about work?
He does. I try to avoid it, but he does talk, he likes to talk about it, so.
So same questions. Are you going to be able to put aside what he tells you about work and be fair and impartial in this case?
Absolutely, yes.
3?
My sister's a Willoughby police officer.
Okay. Same kind of, do you talk about,
Rarely, yeah.
but, you know, whatever you have talked about, will you be able to put that aside and be fair and impartial in this case?
Yes.
5?
I have a cousin who works in Timberlake and that was a detective for 3 months.
Do you talk to them about work?
No.
Okay. Okay, end of my questions. 6?
I have an aunt who's a retired assistant prosecutor, I believe,
Okay, in Lake County?
like Aunt Forever.
Would you ever talk about work with her?
No,
Never talk about the law, anything like that?
not really.
7? Did you ever hand up? No. 10?
Good friends, like county magistrate,
Okay. What kind of magistrate?
like family courts,
Okay.
big thing. We never talk. So, I mean,
Okay.
we see each other, actually on a monthly class dinner.
talk to him about his work?
Not too often, no.
But based on those conversations you've had, can you put those aside and be fair and impartial in this case?
Yes.
Anyone else here? 12?
Yeah, my dad was a police officer over in Shaker Heights for 30 years.
So I'm sure you talked to him about work.
Yeah, and my grandpa, my mom's dad, and then my mom's sister and her husband are both police officers, but they're retired too recently, so.
Would you talk to these people about their job, about work?
Yeah.
Can you put, what they said out of your mind and be fair and impartial? Back here, 32.
Yeah, I know, 3 police officers, 2 in Lake County and 1 in Pittsburgh, Pennsylvania.
Do you talk to them about their work?
The 1 in Pittsburgh, yes, 2 in Lake County, no.
Do you discuss cases with them?
Just stories.
Okay. Can you put those stories aside if you are called as a juror?
Yes.
Anyone else? 34.
I have friends that are cops in the county.
Do you talk to them about their job?
Just a little bit, nothing in detail.
Talk about cases. But what you do talk to them about, you're able to set that aside and be fair and impartial in this case. Listen to the facts and the law. Anyone else? Oh, it's 15.
My uncle was a cop a long time ago when I was a kid.
Okay. Did you talk to him about work?
No, not really. I was probably about 10 years old.
You don't remember anything really? Does anyone have friends or family in corrections? Work at a jail, anything like that? 3?
My cousin does, Lake County Jail.
Lake County Jail, okay. We're gonna have some witnesses from the Lake County Jail. You talk to him about work. Will you be able to put your relationship with him aside and judge those witnesses in a fair and impartial way? Does anyone have any negative feelings towards police officers or law enforcement? You're not gonna hurt his feelings. 8?
Yeah, just like in any profession, I think, there's an opportunity for dishonesty and, also just like speed traps and stuff like that can be negative.
Do you live in Willoughby Hills? So do you think you'd have trouble judging the credibility of a police officer?
I don't think so.
And you'd be able to be fair and impartial? Anyone else? Back here. Has, anyone have close friends or family that are attorneys? 6?
As I mentioned.
Okay, and we talked, you don't talk to her. Anyone else? 15?
Well, that's an attorney.
Did you talk to him about work?
I asked for help around this season for my taxes.
Okay.
That's about it.
Does he do tax?
Yeah, he's more of a financial kind of.
Okay, so not criminal law.
No, not at all.
That's a nice connection to have this time of year.
Yeah, my cousin really agrees.
Well, any of the tax knowledge or whatever else knowledge that you have gained from him, are you able to put that aside and follow the law in this case?
Sure, if you want to call it that knowledge.
Okay. 24?
My brother's insurance.
What kind of law does he practice?
He has a law firm in Louis.
Does he talk about his work with you?
Never.
Oh, sorry, I forgot your number. 34.
My best friend's a defense attorney in Cuyahoga County and Lake County.
Okay. Do you talk to them about work?
Occasionally, yes.
And that's criminal defense?
Yes.
Do you discuss his cases, his clients?
Not just the cases, but not the clients themselves.
Will you be able to put what he says about work, about his cases aside and be fair and impartial in this case? Follow the laws the judge gives it to you? Anyone else? So as you already know, this case is about cocaine. And the actual drugs will be in the courtroom. They'll be wrapped in plastic. But does that make anyone uncomfortable? And without sharing details, again, I don't want to pry, has anyone here, either personal experience or a close family member, struggled with substance abuse? A lot of hands. One.
My older brother passed away from drug overdose.
Will hearing about drugs, testimony about drugs, will that affect you? Anyone else? Four.
Both my parents are addicts.
Will hearing testimony about drugs, will that, affect you?
No.
Five.
My uncle has been convicted of the drug charge.
Kind of same question, will hearing about the drugs, seeing, picture of the drugs, the drug evidence, will that be hard for you? 10.
My brother went through rehab for cocaine and alcohol.
Was that successful ultimately?
Actually, it was. He lived 27 years in AA, so.
Same line of questioning, will that be difficult for you?
Yeah.
9.
Older brother, and then younger brother as well, who overdosed and passed away.
I'm sorry to hear that. So will it be difficult for you to be hearing about, cocaine? Appreciate that. Back here, I saw some hands. 16.
I had a cousin overdose.
Okay. Did they pass away? I apologize. Will it be difficult hearing about cocaine here today? 17.
Both parents were once addicts.
How are they doing today?
My mother passed away, but not anything related to that.
I apologize. Will it be difficult hearing about the drugs here today? I can't see your number.
36.
36.
I've got 3 family members. I'm currently still living. We started with addiction. We are deceased because of it.
Okay. Same question. Will you struggle? Oh, can't see your number. 22.
I have a couple family members convicted, but I was also just hit by a driver that was under the substance. I'm suing them right now.
Oh no!
Yeah, wasn't great.
When was that?
2 months ago, and that happened
In Lake County?
after it happened.
I'm sorry that happened to you. Are you physically okay?
Yeah, very lucky.
All right, well, good luck with that. Well, will it be difficult to hear about, cocaine here today? Anyone else? Does anyone think that drug laws are too harsh or outdated? Right? 2026, I can put whatever I want in my body? Not really that extreme, but I saw some hands. Number?
35.
So you think that drug laws are outdated or too harsh?
I believe that it needs to be looked at a little differently and more, I guess, in the way of helping the people as opposed to
Giving people treatment versus punishment. So would you be able to follow the law as the judge gives it to you and not, he handles the sentencing, what happens after? Will you have difficulty with that?
I don't think so.
Anyone else? You're going to hear from a crime lab analyst in this case. Did anyone know that we had a Lake County crime lab? Has anyone ever toured it? Does anyone know someone that works at the Lake County crime lab? Does anyone have any?
You got it.
Oh, sorry.
35.
35.
A number of years ago, I was with, he was actually a retired police officer, and his brother worked in forensics in the county. I don't know if he still works there.
Okay. Would you talk about his job with him?
No.
I don't have intimate knowledge of how the crime lab operates.
No.
Anyone else? Does anyone have any training or experience in drug chemistry, forensics? Now, I remember we had some nurses. Does anyone have experience or training in reading x-rays? 5?
I could read a basic X-ray.
Same for 6. So there's going to be testimony about an x-ray body scanner. Are you going to be, or how does that make you feel? experience with X-ray. And as you know, I think the judge touched on, and I touched on briefly, it's the role of the judge to worry about sentencing and what happens after this case. Does anyone think they would be too preoccupied or feel sympathetic towards the defendant and not be able to render a guilty verdict, even if the state proved its case? One moment, Your Honor. All right, before I end, any other comments about anything I brought up? Okay. Were there any topics I didn't bring up, but you thought that I would? Okay. That's all.
Thank you, Mr. Matthews.
Thank you, Your Honor. Good morning again, ladies and gentlemen. My name is Jim Matthews, and I represent Mr. Burrell. Going last, a lot of the questions that I would have ordinarily asked have already been asked and answered, but I do have a few things that I do want to go through. You're going to be hearing a lot of testimony from police officers and corrections officers. Now, does anyone think that because of a police officer's or corrections officer's training, that they are inherently a more credible witness? Number
18.
Yes, sir.
I would think somebody that's trained in law enforcement and dealing with that should be a more credible witness.
Does that necessarily mean that they would be?
I would hope they would be. I wouldn't say it's 100%, but I would look at someone in law enforcement probably on a higher level of credibility.
Okay, now, in your instructions, if you are selected, the judge is going to instruct you that police officers, experts, lay people, no one's testimony means more than anyone else's. And if you were selected, would you be able to adhere to that instruction?
Yes.
Okay. Thank you. Does anyone think that police officers or corrections officers are less capable of making mistakes than an average person? Does anyone think that police officers, corrections officers possess superior powers of eyesight? And along that same line, do you think that police or corrections officers possess superior powers of recollection? Now, Mr. Burrell may not testify in this trial. That is his right, and if he chooses to stand on it, does anyone think they would have a problem finding him not guilty without having heard from him directly? Is that going to be an issue if that occurs for anyone? Now, Mr. Burrell has been indicted. He has been charged. And the judge went through what those charges were. Now, does anyone think that he must have done something wrong for it to have made it that far, for him to be on trial today? Does anyone feel that way? And does everyone understand that as Mr. Burrell sits here, he has the presumption of innocence? He is considered not guilty until, if, at some point in time, the state does prove his guilt beyond a reasonable doubt. Does anyone have a problem with that presumption of innocence? Does anyone think that the state is being asked too much to prove him guilty beyond a reasonable doubt? Now, for this question, I would appreciate a verbal answer. If the trial were to end right now, what would your verdict be? Who said unknown? Juror number 10.
Yes, haven't heard anything yet.
Correct, but what is the presumption that we have at this point?
No presumption.
He is presumed to be not guilty as we sit here today.
Right.
So if the trial were to end right now, what would your verdict be?
He's presumed innocent until proven otherwise.
That be,
So that would be not guilty at this point.
thank you. Does anyone disagree with juror number 10? Now I want to talk a little bit about reasonable doubt. And the judge gave you the instruction, he's going to give it to you again, and we're going to talk about it later. But reasonable doubt is the highest standard of proof that we have in our system. We have people going to court and fighting about money. And in a civil case, a money case, the burden is 50.1%. You've got to, just over the line, think that, yeah, one person is liable. That's when we're talking about money. Now, we're talking about someone's freedom. So the standard is very, very different. Now, we can't put a number on it, but civil judgment is like this, beyond a reasonable doubt, far, far greater. Does anyone think that that is too much of a burden to put on the state? Now, at some point, if you are selected as a juror, you're going to take an oath. And does anyone have any doubt in their mind that that oath requires, this is not a suggestion, this oath requires and demands of you, that you acquit Mr. Burrell and find him not guilty unless the state proves each and every element of a charge beyond a reasonable doubt? Does anyone have a problem with that proposition and that burden that will be placed upon the state and that requirement that will be placed upon you? Nobody? All right. Very good. Thank you very much, Your Honor.
Thank you, Mr. Matthews. All right, ladies and gentlemen, at this point, you have been questioned by everybody that's going to question you, almost everybody. So what I'm going to do is excuse you guys. You can go out in the hallway, and you can talk about anything you'd like to talk about, except what we've just talked about for the past hour or so. Okay, that's off limits. Anything else is fine. The only thing I want to do, there are 3 individuals who I want to speak to individually. That's number 3, number 30, and number 35. What we'll do, everybody go out, and then we'll call each of you in individually. And then once the entire panel is called back, then we will identify those individuals who will serve as jurors in this trial, and the remainder will be excused. Okay, so go on out in the hallway and commiserate, and then we'll call you back probably we're looking probably around 20 minutes or so, okay? And then I'll have the bailiff come out and grab the individuals. You are not required to believe the testimony of any witness simply because they were under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your province to determine what testimony is worthy of belief and what testimony is not worthy of belief. The testimony of a defendant is to be weighed by the same rules that apply to other witnesses if the defendant takes a stand and testifies. The defendant has the Fifth Amendment right to not testify in this trial. If the defendant chooses not to testify, you shall not consider that decision for any purpose. You should not decide any issue of fact merely on the basis of the number of witnesses who testify on each side of an issue. Rather, the final test in judging evidence will be the force and weight of the evidence, regardless of the number of witnesses on each side of an issue. The testimony of one witness believed by you is sufficient to prove any fact. During the course of this trial, a number of exhibits and testimony relating to these exhibits may be introduced as evidence. You will determine what weight, if any, the exhibits should receive in light of all of the evidence. Jurors will be permitted to take notes during the trial. Jurors will not be permitted to ask questions of witnesses. It is the responsibility of the lawyers to present all the evidence necessary for you to decide the issues in this case. You will not be permitted access to transcripts of witness testimony during your deliberations. Please be aware that once deliberations have begun, you may not have contact with anyone other than your fellow jurors and the bailiff. This means that once deliberations begin, you will not be able to make any phone calls. We will give you advance warning when we are getting close to the end of the case, so you may wish to let other necessary people know that you will be out of contact once the deliberations begin. You can be reached for emergencies, but if you are called out of the jury room, you will not be able to return. It is important that you be fair and attentive throughout the trial. Do not discuss the case among yourselves or with anyone else. Do not permit anyone to discuss it with you or in your presence. Do not form or express any opinion on the case until it is finally submitted to you. Wear your juror ID so the attorneys, parties, and witnesses know that you are jurors and off limits to them for conversation and contact. It may be difficult for you to understand why you may not discuss this case amongst yourselves until it is submitted to you. You will receive the opening statements, the evidence, the instructions of law, and the arguments of counsel. It would be unfair to discuss the case among yourselves before you receive everything necessary to reach an informed decision. You should explain this rule prohibiting discussion of the case to your family and friends. When the trial is over and your jury duty is complete, you are released from this instruction. At that time, you may discuss the case and your experiences as a juror. I'm going to give you what is called the admonition. It's a standing court order that applies throughout the trial. If I intend to give it, at least a version of it, at every recess, but if I forget, it still remains effective. You have been selected as jurors in this case. We have taken the time to seat a neutral jury so this case can be decided based just on what goes on in the courtroom and not outside influences. You are required to decide this case based solely on the evidence that is presented to you in this courtroom. It is my role as a judge to determine what evidence is admissible and what evidence is not admissible. It would be a violation of your duties and unfair to the parties if you should obtain other information about the case which might be information that is not admissible as evidence. You must carefully listen to all the evidence and evaluate all of it. Do not reach any conclusions until you have heard all the evidence, my instructions of law, and the arguments of the attorneys. Otherwise, you will have an incomplete picture of the case. Do not discuss this case among yourselves or with anyone else. The reason for this is you might be given information or an opinion that could alter the way in which you view the evidence or the instructions or even how this case should come out. Such an opinion or conclusion would be based on an incomplete or inaccurate view of the evidence and therefore would be clearly unfair. In addition, you must not try to get any information from any other source. This ban on outside information includes any personal investigation, visiting the site, looking into news accounts, talking to possible witnesses, reenacting the allegations in the indictment, or any other act that would otherwise affect the fairness and impartiality that you must have as a juror. Finally, you must not have contact with anyone about this case other than me and the court employees. This includes viewing any social media sites of any kind regarding this case or any aspect of your jury service during the trial. If anyone tries to contact you about the case directly or indirectly, do not allow that person to have contact with you. If this person persists in contacting you or speaking with you, this could be jury tampering, which is a very serious offense. If anyone contacts you in this manner, report this to my bailiff or me as quickly as possible. You should know that if the admonition is violated, there could be a mistrial. A mistrial means that the case is stopped before it is finished and must be retried at a later date. This can lead to a great deal of expense for the parties and for the taxpayers. If a mistrial were to be declared based on a violation of the admonition, the juror responsible could be required to pay the cost of the first trial and be punished for contempt of court. Counsel, ready to proceed with opening statements?
Yes, Your Honor.
Ms. Matthews?
Yes, Your Honor.
Ms. Cantor?
Your Honor, I certainly don't see anyone in the courtroom now, but preliminarily, I would ask for separation of witnesses
And that's granted?
and to incorporate the indictment into the opening
And
statement.
that is also granted.
Thank you, Judge. To the court, counsel, ladies and gentlemen, the opening statement allows us to give you an expectation of what you're going to hear throughout the trial, and I believe that to be very straightforward. You're going to hear that the defendant, Toussaint Burrell, was transported and was being booked into the Lake County Jail. And one of the first things you're going to hear is from Lieutenant Eldridge, and he's going to be able to talk to you about the jail, what it is, and the policies regarding the jail, specifically with regards to booking. He's going to be able to describe what that should be from beginning to end. And as you move through the booking process in the jail, there are multiple signs displayed. They are warnings about bringing contraband into the jail and that you will be subject to a full body scan. And so as the defendant is moving through this process, he is scanned, his whole body, and on his lower left leg, there is a foreign object that shows up on that scan. And next, he is patted down and he's changed out. So all of the clothing that he comes in with is removed, all those items are removed, they're searched, they're inventoried, and he's given his jail items. Now, quite frankly, you're going to hear that Corrections Officer Mercado, who completed that scan, did not see the foreign object that was on the defendant's leg. He did not tag that as a positive scan. You're also going to hear that Corrections Officer Ellinger, who did that change-out process I described, did not collect any contraband from the defendant's belongings. And the reason you're going to hear that is they're going to come and testify to that about the mistakes that they made and how that was addressed with them by supervisors. And it was addressed with them, was remedied, and we do have those scans here for you to see. Now, a few days later, on May 30th of 2025, the defendant is being prepared for release from the Lake County Jail. So much the same process. His original items are given back to him. He's going to change into those, and as he's carrying them in the change-out room, a plastic baggie falls from his belongings. And voluntarily, without anyone saying anything to him, he says, "That's trash," and he picks it up, and he throws it in a linen bin that is in the change-out room. Now, Corrections Officer Mason, who is watching this process, that doesn't seem right to him. So after the defendant leaves, he goes back to that linen bin, he searches it, and he finds the plastic baggie that he saw fall from the defendant's belongings, and finds that it is filled with a white crystal-like substance. So he alerts his supervisor, Sergeant Anderson. He comes, he photographs it, they collect it, and then they contact the sheriff's office, and Deputy Nevison goes to the jail, and he collects that item and preserves it as evidence. And lastly, you're going to hear from Crime Lab Analyst James Dawson about what the Crime Lab is and the testing process that that white crystal-like substance underwent. And you will hear that it was confirmed to be cocaine in the amount of 2.71 grams, a Schedule II controlled substance. So after you hear those things, Ms. Bell and I are both going to come before you again, and we're going to ask you to find the defendant guilty of conveying that cocaine into the Lake County Jail and also of possessing it. Thank you.
Thank you. Mr. Matthews.
Thank you, Your Honor. Morning again, ladies and gentlemen. When the state comes right out in their opening statement and starts telling you about all the mistakes that their witnesses have made, I think that is certainly indicative that they have problems with this matter. They're going to spend a lot of time in this trial trying to get you to do two things. One is to look past all of these mistakes, to believe what their witnesses are saying, to believe the conclusions that other witnesses have come to, despite the mistakes that were made in this case. The other is they're going to try to get you to turn assumptions that are being made into facts. Now, I'm certain that you're going to be paying very close attention to everything that is presented, and I am confident that you are going to do neither of those things. You're going to see there is ample reasonable doubt in this case. And I am confident you're going to see that, and you're going to find Mr. Burrell not guilty.
Thank you. Call your first witness.
Thank you, Your Honor. State calls to stand Lieutenant Mario Eldridge.
You raise your right hand, please. You swear testimony you're about to give us the truth, the whole truth, and nothing but the truth, so help you God. All right, have a seat.
Thank you, Judge. Good morning.
Good morning.
Could you state your first and last name, spelling your last name for the record?
Mario Eldridge, E-L-D-R-I-D-G-E.
And where are you currently employed?
Lake County Sheriff's Office.
How long have you been employed there?
Almost 27 years.
And what is your current position at the Lake County Sheriff's Office?
I am in charge of maintenance, kitchen operations, purchasing, and work release.
And that's specific to the Lake County Jail?
Yes.
And what training have you received over the course of your career to hold that position?
I'm certified to the state of Ohio as a corrections officer, and then through continuing education throughout the years of working.
Sir, can you get a little closer to that mic?
And where is the Lake County Jail located?
104 East Erie Street in Painesville.
And what is it connected to?
The sheriff's office.
And in general, what is the jail?
The jail is where we house sentenced and unsentenced inmates until they are either served their time or found not guilty and released.
And are many people brought in to be booked by the jail through a sally port?
Yes.
What is a sally port?
The sally port is a garage, essentially. There's two doors a cruiser can pull in, secure the door, and it allows us to have the inmates removed from the vehicle and brought into the building safely and where they can't escape.
Okay. And when someone is brought in through the sally port, could you walk us through where they would go next within the booking process?
They are brought through a door to a booking counter. At that counter, an officer will meet them, same-sex officer. They will ask them a series of medical questions, remove property, ask them if they have anything on them, remove that property from their pockets, and perform a pat-down search. And then after that, they'll perform a body scan.
Okay. And you've just described moving from the sally port to that booking counter. Are there signs present in those areas?
There are.
And what do those signs say?
There's two signs in the sally port itself. One says you may be subject to a body scan, and the other one states that if you bring contraband weapons or drugs past this point, you can be criminally prosecuted.
Your Honor, may I approach the witness?
Yep.
I'm going to show you it's marked as States Exhibit 1A and 1B. Could you just take those, look at those, and let me know what those are?
Those are the signs in the sally port entering and the signs above the booking counter, or the intake counter in booking.
those are fair and accurate depictions of those signs as you've described them?
Yes.
Your Honor, I would ask to admit and publish State's Exhibit 1A and 1B for the jury.
Any objection to 1A and 1B?
No, Your Honor.
All right, they're admitted.
Get a hold of Bob.
Oh. All right, so with regards to State's Exhibit 1A, could you just describe for the record where this sign is located based on what you've already described?
That is the door, that is the door from the Sally Port entering into the intake area.
And what warning does that provide?
That you may be subject to a body scan, and then on the door states, beyond this point, if you bring contraband weapons or drugs, you are subject to criminal prosecution.
Okay, moving to 1B. Where is this located?
That is at the intake counter, directly above it.
Provides the same warning to inmates?
Correct.
Is the Lake County Jail equipped to provide drug treatments to inmates?
It is.
And what would be some of the concerns about bringing any contraband into the jail?
Contraband of any sorts is a danger to the facility itself. Drugs specifically, if you have someone that's on drug treatment, they can relapse, use drugs, possibly overdose.
You've described some of it, but when individuals are brought into Lake County Jail, what is the standard booking process from beginning to where they are scanned?
So once the intake counter is complete, they pat them down, perform the body scan. They would be brought into the booking area. They are asked a series of questions, where they live. We catalog any property that they bring in. We take that property and secure it, and then they would receive a booking photo and fingerprinted before being changed into a jail uniform.
And you testified to a pat down. How invasive is that pat down?
A pat down search is a search of the outer body of the person, their clothing, anything that could be contained in the clothing or between the clothing and their skin.
And you testified to items being inventoried. Is everything inventoried?
Anything that is catalog found, we would inventory, yes. That would stay in the jail. Anything that would not be accepted into the jail, weapons, drugs, would be turned over to the transporting officer.
And when items are inventoried from an inmate, where do they go after that?
There's a property storage room where we store non-valuable property, and anything of value is sealed in a bag, a clear bag, and labeled with their name, and then it's stored in a separate room that only supervisors have access to.
And what is the training process for new corrections officers with regards to the booking process?
Corrections officers are on training generally for 3 months, sometimes a little longer. During that time, they're assigned to a field training officer. That officer is responsible for them, shows them policies and procedures, ensures that they read the policies of the facility and learn the procedures of the operation.
And the Lake County Jail has a scanning machine?
It does.
And what is that called?
It is a Soder RS. It's manufactured by OD Security, North America.
And when did the jail obtain that scanning machine?
2018, I believe.
And every single person that comes into the jail scanned?
Everybody except for people that would either be pregnant, recently received chemo or radiation, in a wheelchair, juveniles, or have a pacemaker.
And is every corrections officer trained on how to operate the scanner?
They are.
What is the training process for the scanner specifically?
They are trained by their field training officer on the operation, how to read scans, how to utilize the controls of the scan. And then once that is complete, they would take an off training test specifically for the scanner, which includes a radiation safety test and a solder operation test.
Okay, so walk me through the process of how a scan is taken of an individual.
We would instruct the inmate to stand on the platform. Once they stand on the platform with their feet apart, hands out to their side, looking slightly up, we enter their social security number into that, so every inmate has a unique identifier in there, so their scans are tracked by each person. We would start the scan. The platform moves from left to right, takes approximately 7 seconds. During that time, radiation passes through their body and it produces an image to where we can see anything possibly on the outside or inside of that person.
What is the scanner measuring?
It's measuring the density of objects through the body or outside the body.
And how might, based on your training and experience, different densities show up?
On a normal scan, it would be anything that is denser would produce a darker image, and anything that is lighter would be lighter.
How many scans are done of a person?
Generally, just one scan is done. Let me rephrase that. A scan is done, the initial scan when they would do it, we would do one scan. If there's something that possibly looks out of place, we may perform another scan at that time. But anytime they leave the facility and come back, they're always scanned.
Okay. And what are filters with regard to the scanning process?
It just helps you look at the scan in some different views. You can look at it in the normal view. There's a negative view of it, so anything denser would then be white instead of dark. There's a sepia, which gives it a slight reddish hue. There's also an emboss filter, which allows you to kind of peel back the layers of a scan to see different things in there. And then there's a sharpen as well that just kind of enhances the scan a little bit.
And is there a process for servicing that scanner?
There is.
And what is that?
If there's general maintenance is performed weekly, we inspect it, clean it, lubricate it. If there's further service that's needed, then usually it's myself that contacts OD Security North America and requests service by their technicians.
So how do you ensure that this scanner is working properly? Is there a process for that?
Every time we start it up, on an initial startup, it performs a self-test, ensures that it's homed properly to operate properly. The radiation levels, the detector's working, the emergency stops are working. And then yearly I have it inspected to ensure it is producing appropriate levels of radiation.
What is the policy as far as corrections officers taking and reviewing the scans?
The officer that performs the scan is the one that reviews it at that time. If there's questions to that, they would contact the supervisor, who would then perform a second look at that scan and possibly determine that there is or is not something of question.
And after a scan is taken, is it saved by the system?
It is.
How is it saved?
It's saved on a hard drive on the computer.
Is that automatic?
Yes.
Every single scan is saved?
Yes.
How long are those scans retained for?
Positive scans are retained forever. Negative scans can be deleted after 6 months.
So how would you tag a positive scan as you've described it?
There's a checkbox on the scan when you complete the scan where you can check it as a positive scan.
And who has access to those scans?
The supervisors, the administrators of the system.
And how are they pulled from the system?
They would be downloaded to a USB device and then can be printed off or attached to a report electronically.
And as a supervisor, you have access to those scans?
Yes.
And were scans taken of the defendant Toussaint Burrell?
Yes,
And have you accessed and reviewed those scans in the manner that you've just described?
I have.
Your Honor, may I approach the witness?
Yeah.
Hand you what's been marked as State's Exhibits 2A through E. Could you just take a look through those, and when you're finished, look up at them? Okay, what are those?
Those are body scan images from our body scanner.
Okay. Who are the images of?
The defendant,
And you personally accessed those?
I did.
Your Honor, I would ask to admit and publish State's Exhibit 2A through E for the jury.
Any objection to 2A through E?
Oh, Your
All right, they're admitted.
Beginning with State's Exhibit 2A, can you describe for the jury what this is?
That is an image of the body scan image from our body scanner.
Would that be the original scan?
That is an unfiltered scan, yes.
And you testified that only positive scans are tagged and saved.
Yes.
For what reason was this scan tagged and saved?
There's a questionable mark on him that appears to be contraband.
And where is that questionable mark in this photo?
Looking at the image, it would be the right leg, just below the knee, about the calf area.
And then, if this is the original scan, what is done with it after that?
When you're looking at it in the machine itself, you can adjust sliders for lightness, darkness, contrast to enhance the photo unfiltered to look at and see different things.
Okay, moving to 2B. Is that what you've described?
That would be the sepia filter that was applied to that image right there.
2C.
That is the negative.
Are we still able to see, you've described on the lower leg?
I can see it from here, yes.
And 2D.
That would be the emboss filter.
The what? I'm sorry.
Embossing.
And then 2E.
That would be the sharpen mask or sharpen filter for that.
Your Honor, can I just have a moment? I have no further questions, Your Honor.
Cross-examination?
Morning, Lieutenant.
Good morning.
You said that the scan was retained because something unusual was found on the image.
Correct.
But that was not discovered upon the initial reviewing of the scan by the reviewing officer, correct?
Correct.
So at what point was it that the scan was, I guess, reviewed a second time, and we're now saying that there is an image of what you refer to as contraband?
When he was being changed out, there was contraband found in the property room in his property, and they went back and reviewed the scan at that time and marked it as a positive scan.
Okay. So what is in that image that you're,
The image doesn't tell us what it is. It gives us an idea of something being foreign in them. The body scanner is sensitive enough that you can see a BB in somebody's body. In the sense of that, you're seeing something that is protruding from their skin. It's not flush with their outer skin, and it is of a different density than their skin or the clothing around it.
so I mean, you are not coming in here to testify that that spot is a baggie of cocaine?
That spot is something that is not part of a normal scan. That would, at the time of him being scanned, if that was seen, they would have either searched him at that time, they would have performed another pat-down search, they would have asked him again if there was something on him, and they would have performed another scan to see if it had moved, if it was possibly something else.
All right, so before the scan was even done, he had been patted down.
He was asked if he had anything on him. They would always ask if they have anything in their pockets. The statement I would always use is, do you have anything on you that can poke me, stab me, or hurt me, to make sure that there's nothing that's going to potentially hurt the officer. They are asked if they have anything in their pockets, and if they have anything in their pockets or on them at that time, they're to take it out and empty it onto the counter. Again, at the door, they're also warned that if they have anything on them, they potentially need to declare it. They need to declare it at that time, or they face consequences.
So is there a pat-down before the scan?
There is.
And during that pat-down, no contraband was found?
To my knowledge, no.
How do you know when you see a spot that it's a foreign object and not some kind of a growth, tumor, bone spur?
A bone spur would be,
I mean, I don't know. That's why I'm...
it's outside of the skin itself, but it's of a denser, it's denser than the clothing around it. So having looked at a number of scans, it is something that is a red flag and should question who is performing the scan and make them look further into it.
So could that be some kind of a cyst or a growth, or?
I would say probably not, because they tend, I've performed over 800 scans, and there's many people that come in that have skin issues, and they do not show up like that on a body scan.
But you can't say it definitely is not?
No, I can't.
So after the scan, what is the next step that is taken to ensure no contraband enters the jail?
Once they're changed out, they're taken in, once their property's logged, they're taken into a change-out room where an officer will have them place their clothes in a bag to be sealed and placed in a locker, and they're issued a jail uniform.
Now, how do we know that there isn't something concealed within the clothing?
There could be something concealed within the clothing. That's what the body scan helps us find.
Is the clothing itself searched?
The clothing is searched.
So there, after the scan, the inmate removes his clothes, and then the clothing itself is searched?
We don't, after the body scan, we perform the pat-down search. We don't go through the clothing itself, because at that time, when it's placed in a bag, it's sealed, the inmate no longer has access to it, and it would be placed secured to where they don't have access to it.
So each individual item of clothing is not searched before being put in a bag?
Generally not.
But again, just to reiterate, you are not up here testifying that what is on that image is a baggie of cocaine.
I'm not, no. I'm testifying it is something that is of issue.
Thank you, I have no further questions.
Any redirect?
None, Your Honor.
All right, you may step down, thank you.
Thank you.
Next witness?
The state will call Ramon Mercado.
You raise your right hand, please. You swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God. All right, have a seat right here.
Thank you, Your Honor. Could you state your name and spell your last name for the record?
Yeah, my name is Ramon Mercado, Mercado.
Are you currently employed?
Yes, I'm Lake County. I'm right now a cadet in the police academy.
So you're currently attending the police academy?
Yes,
Where are you attending that police academy?
Lakeland.
When did you start the academy?
September 18th,
And when are you expected to graduate?
February 10. I think the graduation should be in March. We don't know exactly the date yet.
And you mentioned you were employed. Are you employed by the county,
Yes,
the sheriff's office?
yes.
Back in May of 2025, where were you employed?
With the Lake County Sheriff's Office at the jail.
In the jail?
Yes,
And what was your position at the Lake County Jail?
correction officer.
How long were you employed as a corrections officer?
2 years and a couple months, exactly, don't know.
Can you describe your duties and responsibilities as a corrections officer?
As a correction officer, we have many. We had to conduct rounds, make sure the safety of the officers and inmates in the jail, as well conduct pat downs. If you're working in booking, you do the intake process. There's many to do. Pass food to the inmates, mail, collect mail. There's many.
So you don't specialize in one area, you're able to work throughout the entire jail?
Yes, you work in all the floors in the jail.
Did you have any training for this position?
Yes, we
Can you
will.
describe that training?
So we are with a 4 officer, training officer is a FDO. You work for 3 months with him. He will guide you through your whole training of the 3 months. He will show you the in and outs of the jail, what to do, how to do it the right way by policy, and he will show you everything that you need to learn.
And at the end of that 3-month period, do you take any exams or certifications?
You take final tests of your FDO training field, and you have to answer all the questions that's in the test and make sure you pass it.
Did you receive training on how to operate the body scanner?
They do. They show you how to work it, what to look for, and in some areas that usually people be hiding like contraband or any items in them.
In what area do people usually hide contraband?
Usually from the throat, this is where they swallow it, chest area, stomach, and by the groin area.
And did you take a test in order to operate that body scanner?
Yes.
Can you briefly describe the book-in process?
The booking process, when the deputies or police officers come into the intake, when they come to the doors, obviously they don't have no weapons or anything, they will put it in a box. When they come in, one of the officers that work in the booking area will receive the inmate in intake, and they will start with a pat down process, ask him some questions like names, date of birth, social security number, and then after that, if the other officer is helping, as well, we'll conduct a pat-down search to make sure there's anything on them that will poke, stab, or anything, or contraband coming into the jail. Then after that, we'll do an intake paper that is for the scanner. You put their name, date of birth, social security number, and ask them some questions that you ask them, like if they've been through, have any head injuries, been in the hospital recently, or been through chemotherapy. Then after that, you take them to the scanner machine and you scan them. When you scan them, you put their social security number and the last name in the machine, and you hit start, and the machine will go through the process.
And how many officers are typically working in the booking area?
And the male side, 2.
And there's different booking for male and female?
Yes, and the female side was separated from the male, and it's from the male on the other side.
Turning your attention to May 28th, 2025, were you on shift that day?
Yes,
Do you remember what shift?
day shift,
What hours is that?
6 a.m. to 6 p.m.
What was your role during that shift?
During that shift, I was working in booking. Me and my partner were working, and we were busy that day. We were going back and forth, getting new inmates and releasing inmates to court as well, to the deputies.
And who was that partner that you were working with?
Officer Ellinger.
Do you recall if that was a busy shift?
Yes,
A lot of people being booked in and booked out?
yes.
Do you recall assisting in the booking in of Toussaint Burrell?
When he came in, my partner was outside with him. I don't recall very well. I think I was in the booking desk doing some paperwork. Then after I saw he was in there, I went outside and provided assistance to do the scanning.
So you did the scanning of Mr. Burrell?
Yes,
Do you see Mr. Burrell in the courtroom here today?
yes.
Could you point out where he's sitting and describe an article of clothing that he's wearing?
It's right there. He got a flannel shirt.
Your Honor, can the record reflect that the witness has pointed out the defendant?
Yes.
Thank you. Was on May 28th, 2025, was the body scanner functioning properly?
Yes.
You didn't receive any error messages or anything like that?
No.
And did you scan the defendant using that same process you described earlier?
Yes.
And was a scan image generated?
Yes.
Would you recognize that image if I showed it to you here today?
Yes.
Your Honor, may I approach the witness?
Yeah.
I'm going to show you what's been previously marked as State's Exhibit A through E. Do take a look at those and just look.
2A?
2A through 2E, and take a look at me when you are done. Do you recognize those images?
Yes.
What are they?
Just different sections of the body scan.
Is it the scan of inmate Toussaint Burrell?
Yes.
Now, back on May 28th, 2025, when you were looking at those scans, did you notice anything unusual?
No.
As you sit here today, do you notice anything unusual?
On the pictures?
Yes.
No.
You don't notice anything unusual on the scan?
No.
Any potential contraband?
No.
After Mr. Burrell was released, did you have to discuss anything with your supervisor about that
Yes.
incident? What was
Yes.
that?
So when I came back after my 2 days off, when I met him and I'm booking that day, the next 2 days I was off. So when I came back to the jail, my supervisor, after briefing in the morning, he asked me to come to the office. He asked me what was my interaction with the inmate that day, and I explained him what I did during that time. And he asked me if I saw anything unusual in the scanning When I did the scanning, I told him no. So then after that, he pointed to me what was brought into the jail during that day when he got scanned. So I told him that I didn't saw it during the whole process. But yeah, so that's what our conversation was.
And then did you have to respond in writing to your supervisor?
No.
Are you sure about that?
Yeah. I got a little note stating what was the conversation we had in the office.
And then looking back at State's Exhibit 2A,
Yeah.
if we look at the defendant's right leg underneath the kneecap, do you notice anything unusual there?
Right now, yes.
So as you sit here today, you do see that abnormality?
Mm-hmm.
But back on May 28th, you did not see that?
No.
And you don't know what that abnormality is, right?
No.
Did you do anything else in the booking in of Toussaint Burrell?
No.
Nothing further.
Cross-examination.
Morning.
So you conducted the scan,
Yes.
and those images appear on some monitor of sorts that you were able to view.
Yes.
And you reviewed all the images.
Yes.
Did you review them thoroughly?
Yes.
And you saw nothing on those images that appeared to you to be contraband?
Yeah, for myself, yes.
And now, you've taken a look at these images again, correct?
Yes.
And now you see something?
I see just a little, I don't know, it's like a little mark in their leg, that's all.
Can you describe the training that you received in reviewing images on the soda machine?
Yes, during that process that you get trained, they will tell you to look to the throat and the main chest area, stomach, and groin area. That's where usually people be hiding contraband, and as well you go through different motions in the machine that it will change the image to different weight of view of the scan.
Do you know approximately how long your training lasted?
For what?
Reviewing images on the soda machine.
We get, I don't know, probably a couple hours during that process.
All right. And during that time, you're trained as to what to look for.
Yes.
You're trained to identify something that could be a foreign object.
Yes.
Okay. And in reviewing those scans with your training, you did not notice anything.
During that date, no, I didn't saw anything that catch my attention. It should be a contraband or anything like that.
Okay. I have nothing further. Thank you.
Any redirect?
One moment, Your Honor. Nothing further.
All right, you may step down. Thank you. Next witness.
The state would call Gavin Ellinger.
Raise your right hand, please. Swear testimony about gives the truth, the whole truth, and nothing but the truth, so help you God.
Swear to tell the whole truth.
All right, have a seat.
Can you please state your name and spell your last name for the record?
Gavin Ellinger. Ellinger.
Are you currently employed?
Yes, ma'am, I am.
Where are you employed?
Lake County Sheriff's Office.
What's your position there?
I'm a correctional officer.
So you work in the Lake County Jail?
Yes, ma'am.
How long have you been employed as a corrections officer?
A year and 10 months.
Can you describe your duties and responsibilities as a corrections officer?
Security and well-being of inmates, management of inmate populations, and general food distribution.
Do you also work the intake and booking area of the jail?
Yes, ma'am.
Did you have any training for this position?
Yes, ma'am.
Can you describe that training?
I went through 6 months of field training and a month of academy training.
And do you take a test at the end of that training?
Yes, ma'am.
Turning your attention to May 28th, 2025, were you on shift that day?
Yes, ma'am.
Do you remember what shift you were working?
I was day shift and booking.
You were working booking. Do you recall if that was a busy shift?
To my knowledge, yes.
Was anyone else working that department or that position with you?
Yes, ma'am.
Who was that?
Officer Mercado.
Do you recall booking in Toussaint Burrell?
Vaguely, yes, ma'am.
And what was your role in his booking?
I was the PAT search officer, medical screener, and change-out officer.
What is a PAT search?
PAT search is just patting down the inmate, searching for any illegal substances and just general searching.
Can you describe the process of a PAT search?
Pat down the arms, torso, legs, shoes, just general searching areas.
And you're looking for foreign objects when you do that?
Yes, ma'am.
And what do you do after the PAT search?
We take them to the soda scanner.
And were you working the scanner that day?
No, ma'am.
Backing up briefly to your PAT search of Mr. Burrell, did you notice anything during that PAT search?
Nothing out of the usual.
So after the PAT search, you went to the scanner?
Yes, ma'am.
And then what happened?
Officer Mercado scanned him. Didn't see anything irregular on the scan. Brought him back to the intake counter. I asked him the medical questionnaire.
What happened next?
After that, after the medical questionnaire was done, inmate Burrell, was brought to Tank 2 until we could book him in.
What is Tank 2?
Tank 2 is a holding area.
So it's before he's ready to go to the rest of the inmate population who waits there?
Yes, ma'am.
Okay, sorry, I cut you off. Go on.
Once we had a moment to book inmates in, we brought inmate Burrell, booked him in, general questions, took his photo, brought him to the change-out room.
What is the change-out room?
Change-out room is a room behind the booking counter. That's where we trade out civilian clothing to inmate uniforms.
So you brought him back there for him to change out of his street clothes and put on the jail uniform?
Yes, ma'am.
And what is that process?
They would have to get in unchanged in front of us. We give them basic uniform top, pants, socks, shoes, t-shirt, shorts, 2 blankets, 1 bedroll, basic hygiene kit.
And is there a little shower back in that area?
Yes, ma'am.
Is that where Mr. Burrell was changing into his jail uniform?
Yes, ma'am.
What happened with his street clothes?
His street clothes were placed in a bag
By Mr. Burrell or by you?
by inmate Burrell.
And what happens with that bag?
We put it into the lockers in the back to keep them for storage until they are released.
Is there any like documentation or tracking that you're able to do of that bag?
Yes, ma'am.
Describe that, please.
During the bookend process, we ask them what they're wearing, what color their underwear is, socks, shoes, and we detail everything and place it into our computer and assign a locker for them.
Do you remember any particular article of clothing that the defendant was wearing that day?
I do believe he was wearing sweatpants and a sweatshirt.
What about an undergarment?
I do believe he had thermal underwear on underneath.
Like a long john, long underwear,
Yes,
type
ma'am.
underwear? Did anyone have access to the defendant's property?
No, after it was placed in a locker, it doesn't get touched until release.
So after you got him changed into his jail clothes, what happened with Mr. Burrell?
We classified him, figure out if he was a minimum, medium, or a maximum, and then he was sent up to general population.
And after that, did you have any other contact with the defendant?
Not that I'm aware of.
Do you see Toussaint Burrell in the courtroom here today?
Yes, ma'am.
Could you point out where he's sitting and describe an article of his clothing?
To the left desk, wearing a flannel.
May the record reflect that the witness has identified the defendant?
Yes.
Did you later learn that contraband was found in Mr. Burrell's property?
Yes, ma'am.
How did you learn that?
I found it while reading reports.
And did you discuss that with your supervisor?
Yes, ma'am.
And did you formally, have a formal written correspondence with your supervisor about that?
Yes, ma'am.
One moment. Now, we discussed how the defendant was, when he was changing out of his street clothes into his jail clothes, he was in that shower area.
Mhm.
Are inmates allowed to be changing in that shower area?
Yes.
And should officers be watching a defendant when they're changing?
Yes, ma'am.
And were you watching Mr. Burrell?
It was kind of a busy day. I do believe something happened, and I took my eyes off of him.
Thank you. Nothing further.
Cross-examination?
Good morning. You conducted a pat-down search of Mr. Burrell.
Yes, sir.
What does that consist of?
Using my hands to find foreign objects, as of patting down the arms, torso, legs, shoes, feet.
Is this a thorough pat-down?
Yes, sir.
So you examined physically, by touch, his legs,
Yes, sir.
and you felt or noticed no foreign objects?
I did not.
I have nothing further. Thank you.
Can you redirect?
Nothing further.
All right, you may step down. Ladies and gentlemen, we're going to take a brief 10-minute break. Remember not to discuss the case among yourselves or with anybody else. Don't try to find out any information from any other source. And do not come to any conclusion until the case is submitted to you. So we'll see you about 8 minutes after 11, okay?
All rise.
Okay, how many do you think you'll conclude before noon?
I think we could.
All of it?
I think so.
All right.
Okay, so, can I use the bathroom? I mean, I can go in there.
Yeah, I don't see any reason why not.
Do I need an
It might be
escort?
we don't really want you in there running around.
Do you need a bailiff?
Yeah, that's fine.
I mean,
I don't mind.
maybe
Whoever needs to
like
take you to the
maybe-
bathroom.